Let us begin with Dalton Prejean, who was only 17 when a dark Louisiana highway changed the course of 2 lives forever. Dalton Prejean was just 17 when a deadly encounter on a Louisiana highway changed his life and ended another. In November 1977, Prejean shot and killed Louisiana State Trooper Donald Cleveland during a traffic stop outside Lafayette. What began as a routine stop became violent, and Prejean was arrested soon after and charged with first-degree murder. Prosecutors sought the death penalty, and a jury agreed, sentencing him to die. His defense raised concerns about his mental health and a troubled upbringing, but those arguments did not persuade the court. Over the next 13 years, his case moved through a long series of appeals. His lawyers argued that his age at the time of the crime and questions about his mental state should spare him from execution, but the courts repeatedly denied relief. By the late 1980s, his legal options had run out. He was executed on May 18, 1990, at the Louisiana State Penitentiary at Angola in the electric chair. He was 30 years old, having spent nearly half his life on death row. Official records do not document a requested last meal, and they do not record any final words. Prejean's case stands as an early example of a juvenile offender executed in the modern era, and it began a pattern seen in several cases of young defendants facing the ultimate punishment after lengthy legal struggles. Charles Rumbaugh was 17 years old when he became the first juvenile executed in the United States after the Supreme Court reinstated the death penalty in 1976. His case unfolded in Texas, a state that would soon become known for its aggressive use of capital punishment against teenage offenders. In 1974, Rumbaugh participated in a robbery that ended with the fatal shooting of a jewelry store owner in Lubbock. He was arrested, tried, and convicted of capital murder. The jury handed down a death sentence, making him one of the youngest people on Texas's death row at the time. Rumbaugh's legal journey was marked by a series of appeals and reversals. His first conviction was overturned, but a retrial resulted in the same outcome, another death sentence. Over the next decade, his case moved through the courts, with defense attorneys raising concerns about his age, his troubled background, and his mental health. Rumbaugh himself often refused to cooperate with his legal team, at times waiving appeals and expressing a desire to accept his sentence. Despite these complications, the courts allowed his execution to proceed. On September 11, 1985, Charles Rumbaugh was executed by lethal injection at the age of 28. He had spent more than a decade on death row, most of his adult life shaped by the prison system. Official records do not document his last meal request, and there is no preserved record of any final statement he may have made. Rumbaugh's execution signaled the beginning of a new era in Texas, where the state would go on to execute more juvenile offenders than any other. His case stands as a stark example of how quickly the machinery of capital punishment resumed for teenage defendants once the legal doors reopened in the modern era. J. Kelly Pinkerton was 17 when he became another early example of Texas's willingness to pursue the death penalty for teenage offenders. In 1979, Pinkerton was accused of the murders of 2 women in Amarillo. The details shocked the community, and police quickly identified Pinkerton as a suspect. He was arrested, charged with capital murder, and brought to trial. The prosecution presented forensic evidence and witness testimony linking him to the scenes. Pinkerton's defense team argued that the evidence was circumstantial and that his confession had been coerced, but the jury was not convinced. He was found guilty and sentenced to death. Pinkerton spent nearly 7 years on death row as his case moved through the Texas appeals system. His attorneys challenged the conviction and sentence, raising questions about the reliability of the confession and the fairness of the trial. Despite these efforts, the courts upheld the original verdict. No new evidence surfaced to change the outcome, and requests for appeals and clemency were denied. On May 15, 1986, J. Kelly Pinkerton was executed by lethal injection at the age of 24. He was the second juvenile offender executed in Texas after the resumption of capital punishment in the modern era. Official records do not indicate what he requested for his last meal, nor do they document any final words he may have spoken. Pinkerton's execution reinforced Texas's emerging pattern. The state was prepared to carry out the ultimate punishment against those who committed serious crimes as teenagers. His case closed out the first wave of juvenile executions in Texas, paving the way for more controversial cases that would follow in the years ahead. Johnny Frank Garrett, 17, Texas. In 1981, he was arrested for the murder of Sister Tadia Benz, a 76-year-old nun found dead in her Amarillo convent on Halloween night. The crime shocked the city, and investigators focused on Garrett after finding his fingerprints inside the convent. He admitted he had been in the building 2 days earlier, saying he had broken in to steal silverware. He explained the fingerprints on a kitchen knife and on a headboard by saying he had handled those items during that earlier break-in. Sister Benz? Sister testified there was no cross above the headboard, a detail that cast doubt on Garrett's explanation. The prosecution relied on that physical evidence and on what authorities described as a confession. After hours of police questioning, officers said Garrett had made an oral confession, but he refused to sign a written statement after consulting a lawyer. The state used this unsigned statement to challenge his testimony at trial. A jailhouse informant also said Garrett had admitted guilt while awaiting trial, testimony that later drew criticism because of possible incentives for cooperation. The role of jailhouse testimony became a central controversy. Garrett's defense argued the investigation was incomplete. No blood type testing was performed on biological evidence from the scene, a forensic gap in a case built largely on circumstantial details. His lawyers highlighted a troubled childhood and concerns about his mental health, and they called Dr. Dorothy Lewis, a forensic psychiatrist, who described him as deeply disturbed and not fit for execution. Appeals courts and the Texas Board of Pardons and Paroles denied relief. In the years after conviction, journalists and attorneys revisited the case, raising questions about the reliability of evidence, the lack of forensic testing, and the unresolved doubts about the confession. Those efforts did not produce a reversal. He was executed on February 11, 1992, by lethal injection at the age of 28. Official records do not document his last meal or any final statement. The unanswered questions about evidence, mental health, and the possibility of wrongful conviction have made Garrett's case a lasting example of the controversies surrounding juvenile executions in the United States. Ruben Cantu was 17 years old when he was accused of a deadly robbery in San Antonio, Texas. The incident occurred in 1984 during an attempted theft at a construction site. 2 men were shot. 1 man died and another survived. Cantu, a high school dropout with no prior violent record, was arrested and charged with capital murder. Prosecutors relied heavily on the testimony of the surviving victim, who identified Cantu as the shooter. The case moved quickly through the courts. His defense argued that he was not at the scene and that the evidence against him was thin. But a jury returned a guilty verdict and sentenced him to death. Over the years, Cantu's conviction attracted growing attention from journalists and legal advocates. In the early 2000s, the San Antonio Express-News published an extensive investigation that uncovered troubling details. The surviving victim, Juan Moreno, later recanted his trial testimony, saying police had pressured him to identify Cantu and that he had feared for his own safety. Moreno insisted that Cantu was not the shooter and that he had tried to tell authorities the truth before the trial, but had been ignored. Another key witness, David Garza, who had been with Cantu on the night of the crime, also said that Cantu was not involved. These accounts raised new doubts about the reliability of the conviction. No physical evidence ever tied Cantu to the scene. There were no fingerprints, no DNA, and no weapon was recovered. The prosecution's case had rested almost entirely on eyewitness statements. As the story unfolded in the press, questions grew about police procedures, the pressure placed on witnesses, and the lack of forensic support for the charges. Despite these concerns, the courts had already denied all appeals. Cantu's defense team had raised issues about his age, his background, and the fairness of the trial, but none of these arguments changed the outcome. On August 24, 1993, Ruben Cantu was executed by lethal injection at the age of 26. Official records do not list his last meal or any final statement. His case became one of the most debated in Texas death penalty history, with many legal experts and journalists pointing to it as a possible example of wrongful execution. The controversy surrounding Cantu's conviction and the later recantations by key witnesses fueled ongoing debate about the reliability of eyewitness testimony and the risk of irreversible error in capital cases involving juveniles. Cantu's story remains a stark reminder of how contested evidence and post-execution revelations can leave lasting questions about justice. Douglas Christopher Thomas was 17 when he was charged with capital murder in Virginia. In November 1990, Thomas and his girlfriend Jessica Wiseman were accused of killing her parents in their King William County home. Prosecutors argued that Thomas had played a leading role in the plan, citing evidence of premeditation and the violent nature of the attack. The trial lasted less than 2 weeks. The jury found Thomas guilty and sentenced him to death. His defense raised questions about his maturity, his relationship with Wiseman, and his ability to understand the consequences of his actions. But those arguments did not persuade the court. As the years passed, Thomas's legal team filed a series of appeals. After the Supreme Court's 2002 decision in Atkins v. Virginia, which barred the execution of people with intellectual disabilities, Thomas's lawyers argued that he should be spared under the new standard. They submitted evidence of low IQ scores and difficulties in school, saying his intellectual limitations affected his judgment at the time of the crime. Virginia courts reviewed the appeals but declined to halt the execution, finding that the evidence did not meet the threshold set by Atkins. With all appeals exhausted, Thomas remained on death row. He was executed on January 10, 2000 by lethal injection at the Greensville Correctional Center. He was 26 years old. Official records do not list a requested last meal, and they do not record any final words. The legal arguments raised in his case, especially those about intellectual disability, became more common in the years ahead as courts grappled with the implications of Atkins for other death row inmates. Toronto Patterson was also 17 when he was arrested for a triple homicide in Dallas, Texas. In 1995, Patterson was charged with killing 3 members of his cousin's family during a robbery. The case moved quickly through the system. Prosecutors presented evidence of motive and opportunity, and the jury returned a guilty verdict. Patterson was sentenced to death. His attorneys later argued that he had a history of learning difficulties and low IQ scores. They submitted school records and psychological evaluations, saying that under the evolving standards set by Atkins, his intellectual capacity should exempt him from execution. The courts reviewed these arguments, but ultimately rejected them, stating that the evidence did not establish intellectual disability as defined by law. He was executed on August 28, 2002 by lethal injection. He was 24 years old. Official records do not list a last meal request or any final statement. Patterson was one of the last juveniles executed in the United States before the Supreme Court's 2005 ruling in Roper v. Simmons. The cases of Thomas and Patterson highlight a period of legal uncertainty as defense attorneys increasingly invoked intellectual disability as a bar to execution, while courts were slow to accept those claims. Their stories show how close the justice system came to changing course just before the law shifted for good. Sean Sellers was 16 when he was arrested in Oklahoma for a series of murders that drew national attention to questions of mental health and the death penalty. In 1985, Sellers killed a convenience store clerk during a robbery. Months later, he shot and killed his mother and stepfather while they slept. The investigation led police to Sellers, who confessed to the crimes and described his actions in detail. At trial, prosecutors said he had planned the murders and showed no remorse. The jury convicted him of capital murder, and the court sentenced him to death. Sellers became the only person in the United States executed for crimes committed at age 16 since the reinstatement of the death penalty in 1976. From the beginning, Sellers' case stood out for its focus on psychological issues. His defense team presented evidence that he had suffered from severe mental health problems, including a diagnosis of multiple personality disorder. Sellers himself said he was under the influence of a demonic entity at the time of the killings and that he had no control over his actions. Psychiatrists who evaluated him during appeals reported a long history of trauma and psychiatric symptoms, including dissociation and periods of lost time. These clinical findings became the centerpiece of his legal strategy as his case moved through the courts. Despite the documented mental health concerns, Oklahoma courts repeatedly denied Sellers' appeals. The state argued he was competent to stand trial and understood the consequences of his actions, pointing to his detailed confessions and the calculated nature of the crimes. Sellers' attorneys brought his case before federal courts and sought clemency from the governor, emphasizing his age at the time of the offenses and the psychiatric evaluations, suggesting he was not fully responsible. None of these efforts succeeded. The courts maintained that his mental illness did not meet the legal standard for insanity or for incompetence to be executed under the laws at the time. On February 4, 1999, Sean Sellers was executed by lethal injection at the Oklahoma State Penitentiary. He was 29 years old, having spent more than a decade on death row. Official records do not specify a last meal, nor do they preserve any final words he may have spoken. Sellers' case remains a stark example of how courts treated mental health evidence in juvenile capital cases during that era. Even with documented psychiatric diagnoses and a history of trauma, the justice system allowed his execution to proceed. His story continues to raise serious questions about the intersection of youth, mental illness, and the death penalty in America. Glenn McGinnis was 17 when he was arrested for the robbery and murder of a laundromat clerk in Conroe, Texas. The crime occurred in 1990, during a period when Texas courts routinely pursued capital punishment for teenage offenders. Prosecutors argued that McGinnis entered the laundromat armed and shot the clerk during a robbery gone wrong. The evidence included witness statements and McGinnis's own confession, which he later claimed was coerced. Despite his age and claims of a troubled upbringing, the jury found him guilty of capital murder and sentenced him to death. During his years on death row, McGinnis's case drew attention from advocates who pointed to his background. Raised by a single mother, shuttled between relatives, and exposed to violence from an early age. Appeals raised questions about his maturity, the quality of his legal defense, and whether a teenager should face the death penalty. Yet the courts upheld his conviction and sentence at every stage. By the end of the 1990s, McGinnis had exhausted all legal avenues. On January 25, 2000, at age 27, he was executed by lethal injection at the Texas Department of Criminal Justice Huntsville unit. Official records do not list his last meal request or any final words. McGinnis's execution came at a time when the debate over juvenile capital punishment was growing louder, but the law had not yet changed. Napoleon Beasley was also 17 when he was charged with capital murder in Texas. In April 1994, Beasley shot and killed John Luttig, the father of a federal judge, during a carjacking in Tyler. The crime was swift and violent, and Beasley's arrest followed soon after. Prosecutors emphasized the premeditated nature of the act, while Beasley's defense argued that impulsivity, youth, and lack of criminal history should be considered. The jury delivered a death sentence. The case quickly gained national attention, not only because of the victim's prominent family, but also because of Beasley's age and the racial dynamics involved. A black teenager sentenced to die for killing a white man in East Texas. Beasley's appeals became a focal point for activists and legal scholars. His attorneys filed repeated petitions for clemency, arguing that his sentence was out of step with evolving standards of justice. The case reached the U.S. Supreme Court multiple times in the final weeks before his execution. Several justices recused themselves due to personal connections, but the remaining court declined to intervene. Despite public campaigns and international calls for mercy, Texas officials refused to grant a stay or commute the sentence. On May 28, 2002, at age 25, Napoleon Beasley was executed by lethal injection. Official records do not document his last meal or final statement. His execution stands as one of the last of its kind in the United States. A teenager put to death after years of legal and public debate about whether such punishment should be allowed. The proximity of Beasley's case to the Supreme Court's 2005 ban on juvenile executions highlighted how close the nation came to a constitutional turning point. George Stinney Jr. was only 14 years old when he was brought before a South Carolina court in June 1944. He was accused of the murder of two young white girls, Betty June Binnicker and Mary Emma Thames, in the small mill town of Alcolu. Stinney, an African-American boy, was arrested and interrogated without a lawyer or his parents present. Within days, police announced that he had confessed, though no written or signed statement was ever produced. 14 years old and questioned alone, he faced a system that offered little protection. The trial began just a month after the girls died. It lasted barely 3 hours from start to finish. Stinney's appointed attorney, a local tax lawyer with no experience in capital cases, called no witnesses and did not cross-examine key prosecution testimony. The all-white jury, drawn from a segregated pool in Jim Crow-era South Carolina, deliberated for only 10 minutes before returning a guilty verdict. The judge sentenced Stinney to death by electrocution, the state's standard method at the time. The speed and limited defense were striking, and they raised immediate concerns about fairness. 3 hours was all it took to decide a life. News accounts from the period described a tense courtroom packed with white townspeople. Outside, the threat of mob violence hung over the proceedings. Stinney's family, fearing for their safety, had already fled town. No appeals were filed. The legal process moved with extraordinary speed, offering little opportunity for review or reconsideration. The racial context and the fear of unrest shaped what happened inside and outside the courtroom. Mob threats were part of the atmosphere. On June 16, 1944, exactly 2 months after the girls died, George Stinney Jr. was led to the electric chair at the South Carolina State Penitentiary. At just 5 feet 1 inch tall and weighing around 90 pounds, he was so small that the executioners had to seat him on a Bible to reach the straps. The oversized mask slipped from his face during the procedure, and witnesses later recalled the haunting image of the boy's tears. Stinney remains the youngest person executed in the United States in the 20th century. Electrocution ended the life of a child. The swiftness of the trial, the absence of a meaningful defense, and the racial context of the Deep South in 1944 combined to deny Stinney basic protections of due process. His case stands as a stark example of how the justice system could fail its most vulnerable defendants, especially in an era shaped by segregation and racial violence. Due process was not afforded, and the consequences were irreversible. 70 years after George Stinney Jr.'s execution, the story returned to a South Carolina courtroom. In January 2014, a 2-day hearing brought together historians, legal experts, and surviving relatives. They examined the original trial record, the lack of defense, and the hasty proceedings that had condemned a 14-year-old boy. Witnesses described how Stinney was questioned alone by law enforcement, with no parent or attorney present. No written confessions existed. The defense at the original trial had called no witnesses, presented no evidence, and failed to challenge the prosecution's case. The all-white jury had needed just 10 minutes to decide his fate. At the hearing, new testimony and historical records painted a picture of a trial shaped by fear and the deep racial divide of the Jim Crow South. Legal scholars argued that Stinney's rights had been violated at every turn. His family, who had been forced to flee town after his arrest, spoke about the impact of his loss and the injustice that followed them for generations. The judge reviewed the evidence and the conduct of the original trial, noting the absence of due process and the overwhelming pressure on all involved. On December 17, 2014, the court issued its decision. The conviction of George Stinney Jr. was vacated. The order described the 1944 trial as a miscarriage of justice, citing the failure to provide a fair defense and the speed with which the verdict and sentence were delivered. The ruling did not change the outcome for Stinney or the families of Betty June Binnicker and Mary Emma Thames, whose deaths had shattered the community so many years before. But the court's action carried a message. The legal system, even decades later, could acknowledge its mistakes. The vacatur of Stinney's conviction stands as a rare and powerful admission by the courts. It recognized that the original trial had denied a child the most basic protections. The case now serves as a symbol of the dangers that can arise when justice is rushed and when prejudice and fear override the rights of the accused. For many, the 2014 decision offered a measure of dignity to Stinney's memory and a warning for future generations about the cost of injustice. The United States remains the only Western democracy to have executed people for crimes committed as children within living memory. Even now, nearly 80% of the world's juvenile death sentences are handed down in just a handful of countries. What we choose to remember and what we refuse to repeat still shapes the boundaries of justice today. The past is not just history, it is the mirror we hold to our present. Share your thoughts below.